I actually started out life as a public international law lawyer, and I am still in that field. After my initial training as a lawyer, I specialised in public international law at University College London with an LLM. I actually started a PhD in the field of public international law, customary international law. So I didn't finish that. In fact, I moved both in terms of thesis supervisor and topic towards international economic law, but that was partly because I'd started teaching in the field of international economic law, and specifically in the area of trade, which is what I still do to this day. So that began to influence my research and eventually led me to write a doctorate in the field of international economic law. So when it comes to public international law, I'm still very much on board, and in fact in all the areas, general international law, so areas of doctrine, sources, also big areas like treaties and state responsibility, all those things are important to me, and I still use them in my teaching. A good example of that is teaching international investment law, where we have to look at issues of attributing various acts that have been committed by the state, or state organs. We have to attribute those to the state or to the government of a host state, and we do that on the basis of the ILC draft articles on state responsibility. So public international law remains very much at the centre of everything I do. But what is interesting is that many of the students that I teach today actually live and work much more within a silo of competence. So they're only interested in international economic law, so in trade law or investment or international monetary law, something like that, financial law. That's all they're concerned about. And that can sometimes be quite tough as a teacher, as an educator, in trying to get them to understand the broader picture and understand where general public international law fits in. So that's really, but I have to say, I think if you study international economic law, you do actually become acquainted with many of the broader fields of public international law, if you open your eyes, your ears and your mind towards developing that interest. That's, I think, very difficult to say. Probably it's knowing where exactly to focus on, which sort of area, or if you want to specialise, which specialisation. Students often ask me that. Many students that come and study, at least at our university, actually want to go into practice, or a few of them want to join an international organisation. Many of them will be practice orientated, even if they're thinking about public international law, because they're thinking, well, you know, I can do one of these big cases at the ICJ or in one of the European courts or something like that, and so they tend to focus on these sort of areas. So they want to know what to do in order to be selected for practice and beyond their domestic bar. But the question more generally, I think, is how do we... law is always a bit too reactionary. It reacts, it's not proactive, it's retrospective in acting. It acts in accordance with a political situation that has maybe taken place or is ongoing. The Syria conflict is a very good one, for example. In 10 years' time, we'll look back and say, well, perhaps we should have dealt with some of those incidents that took place in a different way than it was dealt with. And maybe the law should have been applied more vigorously, and there should have been more follow-up on UN sanctions and things like that. But at the time, it's very difficult. And I think that's an ongoing challenge, and one that all of us face. We also face the problem, I think, in the academy, in teaching public international law. And it doesn't apply in international economic law, by the way, but in public international law, we're still teaching students based on lots of old cases from the ICJ and the Permanent Court of International Justice, as if these are really so important. You know, I think we've just about moved away from the Nicaragua case, but if, for example, you go to the United States, they're still talking about the Lotus Doctrine. And I'm just like stunned, you know, why? Why is that so relevant? But that's probably because they consider international law to be the foreign relations law of the United States. It's their particular approach. So I think that's almost a disservice we do our students, because in the real world that's not what it's like. And that's a big discrepancy or difference with international economic law, where we teach from the cases that have actually just been handed down, sometimes as recently as this year. And so students are much more up to date, and they're more interested, they're more engaged, and they can see things happening around them within that particular field. This is a difficult one because, and it takes a lot of students some time to realise it, we're dealing with real asymmetry, because you're dealing with host state governments that are public international law actors, they're sovereign states, and you're dealing with corporate actors, corporations. So they are they're private actors, they're incorporated or established in a particular state, so they're non-state actors, and the relationship between them is very different. So you're looking at the protection of foreign investment in the way that you look at the protection of human rights of individuals. And what doesn't come out very well, but it does when you study the subject, is I think the dispute settlement system is very difficult to understand until you've understood that very peculiar asymmetrical relationship that exists between the foreign investor, that's usually a corporate actor, in a foreign host state, and how that leads to this interesting investor-state arbitration, and how the arbitral panels often side very much with the investor. They shouldn't do. We're seeing some reaction to that, what's called regulatory rebalancing, tribunals also considering the arguments put forward by many governments. Some of them are involved in legitimate governmental measures and need to regulate state activity or private activity as well. And I think that is a really difficult thing to get across. Another area that I'm also working on at the moment, and I've just begun teaching a module on it this year, is business and human rights. And again, you've got this peculiar relationship between the corporate or business actor and the state. The state is responsible, ultimately, is the bearer, the primary bearer of obligations in terms of the protection of human rights, but that leaves many corporate entities not having to protect human rights, but all that we're asking to do is to respect human rights. But again, that asymmetry is at work there. In terms of contribution, I think the area is still quite new for women. Why do I say that? Because there has been more progression for women into the field of public international law than a generation ago, but it's still very slow. And we can still almost count on one hand the more prominent women in the field. They are people like Chris Chinkin, Hilary Charlesworth, probably today Laurence Poisson de Chazourne from Geneva, Brigitte Stern, who does a lot of work in field, she's an investment arbitrator. We're talking about probably about 5 or 6 women. I'm trying to think, there are a few in the US as well, but I mean, we're far from having a very, people like Rosalind Higgins, who was the first woman appointed to the International Court of Justice, and later becoming its president. So these people are the sort of landmarks, if you like, but we're still not really close. In terms of international economic law, would probably be people like Laurence Poisson de Chazour, maybe Hélène Ruiz-Fabry. These are both French nationals, by the way. I can't really point to any British people or US. No, it's really difficult. And a lot of women don't automatically think of this, of international economic law, as a field for them to engage with. It's very male-orientated. Men tend to drown out women's voices. We see it everywhere, even in the selection of panelists for WTO panels or for arbitration tribunals, for investment arbitration. I'm not saying that women aren't chosen. There's Gabrielle Kaufmann-Kohler from Switzerland, who's a very frequent arbitrator, but it's still relatively new ground for us. I'm sorry to say that, but it's true. In fact, the human rights regime and the teaching and education human rights tends to be more populated by women for whatever reason, and they tend to be larger constituencies in our classrooms as well. But to come back to Nottingham International Law Security Centre, we are still struggling to really get this off the ground. I think we don't have quite enough women in the centre. We have quite a few female PhD students, so we're hoping to bring them more in and involve them more with the work of the centre. It has been a difficult start, I think, because I myself have a couple of other roles, and so does my co-director. We don't have any particular areas of expertise within the centre that are very gendered in any respect. The idea is just to provide diversity and equality, so it's open to men and to women. But we still have to really get a good programme going. And it comes to, I think, promotion and interview. I think a lot of women are passed over. Why are they passed over? And this has applied to me. I think there is sadly still very much a male culture out there with selection. I think there's a bias towards male candidates. I do think, though, that some of us women are, and myself included, are not necessarily helping ourselves. We're often not as confident as we could be. We tend to question ourselves too much, and we're often too honest. A lot of men in interviews, no, it's true, in interviews and other promotion rounds and things like that, they boast about how wonderful they are, and actually they're often not very good at all, but they get the job. I think we probably need to spend a lot more time on bringing women along. In fact, I have started an initiative within my own law school to try and discuss some of these issues with our female academics as to how we may help them and support them. And also, and that's another thing that doesn't count in the male society very much, is we have a difficult work-life balance. Many of us have families or other caring relationships that we need to support, and often that excludes us from certain parts of the process, an after-work drink or something like that, a social event. And I think that's very tough. If I'm honest, it probably comes out of teaching. I think overall that has been the most rewarding experience. If I think back every time I look at the real high points, and some of the people that I have also been my PhD students that have gone on to build their own careers. And I think if you can transfer knowledge to another person and they can take that knowledge and use it and benefit their whole life, I think that's very precious. So I think that's the reward for me, seeing that happen. But I think my male colleagues would say something different. Living and working in Italy, I worked for an international organisation, so that was very much within the frame of an organisation, so that has a particular culture of its own. And that's more open, more equality based. Working in the Netherlands in academia, the glass ceiling, so to speak, is very firmly in place. It's extremely difficult for Dutch or foreign-born women to be promoted and to make a real success of their careers in the Netherlands is unbelievably. It's one of the worst countries in Europe. Denmark is also similarly bad. So a lot of people don't know this, but it's very much. Here in the UK, we're much more egalitarian. We give women a chance. So my first chair didn't come in the Netherlands, which is where I was working previously. It came here. I think it's got easier for women, but we're still a long way from achieving equality with men. There's a lot that's happened. I think it's become easier for women to build a career, particularly because of the maternity leave, and we didn't have that in our days, not to the extent it is available now. Caring, nurseries, all these sorts of things. I think that helps tremendously. But we're still not completely on board with everything. My own university, for example, they're going to impose timings on us, and some of the women have asked that they be excluded from the 9 o'clock start because of having to get children to school, and that has been turned down by the university. So this is what I mean. We've made huge progress, but there are small incremental changes that could be brought in without too much trouble, and many institutions aren't prepared to do that.